What happens when your state passes a data privacy law so strict that the world's biggest tech companies threaten to relocate their headquarters? When the companies that built Silicon Valley start evaluating Austin, Miami, and Denver as replacement homes? When a single regulatory framework could trigger the largest corporate exodus in American history and cost California an estimated $80 billion in annual economic activity? I'm Elizabeth Morgan, and welcome to the Elizabeth Morgan channel. Before we dive into this investigation, I need you to do something. Hit that like button right now, subscribe to this channel, and drop a comment below with your thoughts on what's happening. Share this video with anyone who needs to understand what's really going on. This story needs to get out there. This matters because we're talking about an estimated 250,000 to 350,000 high-paying tech jobs at immediate risk across California. Jobs that pay an average of $160,000 to $240,000 annually according to industry compensation data. We're talking about the tax revenue that funds California schools, infrastructure, and social programs. We're talking about the companies that turned California into the world's fifth largest economy, companies now publicly discussing relocation timelines. Right now, as you watch this, major tech companies including Meta, Google, Apple, Amazon, and dozens of smaller firms are conducting formal headquarters relocation studies. Not exploratory conversations, not contingency planning. Active real estate searches in other states, lease negotiations for multi-million square foot campuses in Texas and Florida, hiring freezes in California offices paired with aggressive expansion in other markets. This is happening today, in real time as we speak. Board meetings are being held where executives present California exit strategies. Real estate consultants are being hired to identify alternative locations. State tax attorneys are modeling the savings from relocating. And California officials are watching the companies that built their tax base, that employ hundreds of thousands of residents, prepare to leave because of a law the governor signed 6 months ago. This is the investigation into how California's Consumer Data Protection Act, designed to protect privacy, is instead triggering a tech industry exodus that could devastate the state's economy. What you're about to hear should concern every Californian who wonders why the state keeps losing the industries it created, and every American who cares about where innovation happens. This channel brings you the investigations mainstream media won't touch. Not because they can't, but because it exposes how privacy regulations, however well-intentioned, can create compliance costs so extreme that even trillion-dollar companies choose relocation over adaptation. Because this isn't just a tech story, it's an economic survival story for California. How did California, the birthplace of Google, Facebook, Apple, and the modern internet, reach a point where these same companies are planning departures? What happens when a governor gets squeezed between privacy advocates demanding stronger protections and business leaders saying the regulations make California operations economically impossible? And what are the consequences when political principles meet economic mathematics and the result is the destruction of the state's most valuable industry? Let's follow the legislation, the corporate response, the families who won't get those jobs, and the fiscal crisis California officials didn't anticipate. Because this isn't speculation, this is a developing emergency. In the fall of 2023, the promise looked almost noble. California legislators, privacy advocates, and consumer protection groups talked about the Enhanced Consumer Data Protection Act as groundbreaking legislation that would give Californians unprecedented control over their personal information. The law would require companies to get explicit consent before collecting data, allow users to demand deletion of all stored information, prohibit most behavioral tracking, and impose massive penalties for violations. And when you hear that from a privacy perspective, you think, good, we should control our own data. The proposal promised to protect consumers from corporate surveillance, prevent data breaches, stop manipulative advertising, and establish California as the global leader in digital privacy rights. Policy advocates projected that if California could implement strong privacy protections, the state would become the model for the nation and potentially the world. Other states would adopt similar frameworks. Federal legislation might follow California's lead. Economic forecasters supporting the legislation argued it could actually boost California's tech sector by creating trust, by making users more comfortable with technology. Some analysts projected the privacy tech industry itself could create 20,000 to 35,000 jobs in California, helping companies achieve compliance. Picture it. A startup in San Francisco building privacy-first social media where users control every piece of data. An established company in Mountain View implementing world-class privacy protections and using that as competitive advantage. This wasn't supposed to trigger corporate exodus. It was supposed to be California innovating, protecting consumers, showing that technology and privacy could coexist. Companies would adapt. Users would benefit. California would lead. Reports suggest proponents even argued that tech companies were so deeply rooted in California that they'd absorb compliance costs rather than consider relocating. The assumption was that proximity to venture capital, access to Stanford and Berkeley talent, and network effects were valuable enough that companies would pay the regulatory premium. Hope, real hope. Then the law passed, and then everything changed. By late 2024, California legislators passed the Enhanced Consumer Data Protection Act in a ceremony celebrating privacy rights. Privacy advocates applaud, consumer groups celebrate, and then companies start reading the compliance requirements, and then the lawyers start calculating costs, and then the impossible mathematics become clear. Here's where everything falls apart. The regulation, according to legal analysts who've studied the implementation framework, doesn't just require asking permission before collecting data. It creates what tech companies describe as an operationally impossible compliance structure that would fundamentally change how digital services work. Start with the consent requirements. The law reportedly mandates that companies must obtain explicit, informed, specific consent for every individual data point collected, for every use of that data, renewed annually. In plain language, this means a social media company couldn't just ask, "Can we use your data?" They'd need separate consent for your name, email, location, browsing history, friend connections, posted content, and then separate additional consent for each way that data might be used. Legal experts estimate a typical user would need to click through approximately 150 to 300 individual consent requests to use basic platform features. And those consents would expire after 1 year, requiring the entire process annually. Industry analysts call it death by consent fatigue. For a major tech company, compliance attorneys estimate the consent management infrastructure alone could cost $200 to $500 million to build and $50 to $100 million annually to operate. But that's just the beginning. The data deletion requirements essentially require companies to architect their entire data systems around the assumption that any piece of information might need to be permanently deleted within 48 hours of user request. Here's why that's catastrophic. Modern tech platforms don't store data in simple databases where you can just delete a row. Data is distributed across hundreds of systems, backup servers, content delivery networks, analytics databases, machine learning training sets, archived logs, partner integrations. Engineers estimate that building systems capable of the deletion requirements would require complete architectural redesign. Costs for a company like Meta or Google, an estimated $5 to $15 billion in engineering effort over 3 to 5 years. And even then, technical experts say true compliance might be physically impossible given how modern distributed systems work. Then there's the penalty structure. The law reportedly allows fines of up to $10,000 per violation per user. For a platform with 50 million California users, a single systemic compliance failure could theoretically trigger $500 billion in penalties. Here's the math companies are running. Attempt compliance in California, spend billions rebuilding systems, accept massive legal liability exposure, or relocate headquarters to Texas or Florida, states with no equivalent regulations. The calculation wasn't close. tax attorneys and corporate strategists reportedly advised clients that California had become the highest-risk state in the nation for tech company headquarters. Not just expensive, but existentially dangerous from a legal liability perspective. State officials believed tech companies were too integrated into California's ecosystem to seriously consider leaving. The assumption was that decades of investment, established campuses, and recruited talent meant companies would find ways to comply rather than relocate. That assumption is proving catastrophically wrong. Think about the software engineer at Google, working on search algorithms, earning $280,000 annually. She's been in Mountain View for 8 years, built a life, bought a house, established community. In February 2025, Google announces it's relocating its primary search engineering division to Austin. The stated reason: California's regulatory environment has become incompatible with continued innovation. Approximately 8,000 positions are moving. She faces an impossible choice: uproot her life, sell her house in a suddenly weakening market, move to Texas, or stay in California, leave Google, try finding equivalent work in a tech sector that's actively shrinking. She's not alone. Thousands of Google employees face identical decisions. Or consider the startup founder in San Francisco who raised $30 million to build an AI-powered personal assistant. His technology uses data to learn user preferences and provide proactive help. Under California's new law, it's potentially illegal. His lawyers tell him compliance would cost approximately $8 million of his $30 million in funding, would require scaling back core features, and would still leave the company exposed to devastating liability. His investors demand relocation. The startup announces relocation to Miami. The innovation, the jobs, the tax revenue, all leave California. Stories like this are playing out across Silicon Valley, and they don't start in board meetings. They start when a founder realizes their business model is illegal in their home state, when an engineer learns their project is moving, when a product manager discovers California regulations prohibit the features that make their product competitive. Picture a mid-sized tech company in San Jose, 2,500 employees, profitable, growing. They provide marketing analytics services using consumer data to help companies understand customers. California's law reportedly makes their core service illegal without consent processes so complex that most consumers would abandon them. The company estimates California compliance would reduce revenue by 40 to 60%, while increasing costs by $35 to $50 million annually. The board meets. The options are clear: shut down California business and lay off most staff, or relocate to a state where the business remains legal and viable. They choose relocation. 2,500 jobs leave California. The tax revenue leaves. The economic activity leaves. Not because of market failure, because California regulations made their business impossible to operate profitably. What remained were for lease signs on office buildings, empty cafeterias, parking lots where nobody parks. Not because companies failed, because California policy made success impossible. Now let me show you how this turns from a tech policy issue into a statewide economic catastrophe. Because it's not just one company leaving, it's a pattern accelerating across the entire sector simultaneously. This is what a perfect storm looks like. While major tech companies announce relocation studies, venture capital reacts immediately. VC firms adjust, redirect, invest where regulatory environments support growth. Reports from Sand Hill Road indicate dramatic shifts. Firms that historically invested 70 to 80% of funds in California companies are now directing 50 to 60% to Texas, Florida, and other states. The capital that built California's tech dominance is flowing elsewhere. At the same time, talent migration accelerates. Engineers don't need to wait for employers to relocate. They apply directly to growing tech hubs in Austin, Miami, Denver. LinkedIn data reportedly shows California tech workers updating profiles with open to relocation at rates 300 to 400% higher than historical averages. And then real estate markets react. Commercial real estate in Silicon Valley is showing vacancy rates climbing toward 25 to 35% in some submarkets. Residential real estate in tech-heavy areas is softening as the jobs supporting those housing prices disappear. Meanwhile, other states aren't passive. Texas, Florida, and Arizona are running aggressive recruitment campaigns specifically targeting California tech companies. Governors are personally calling CEOs. Economic development offices are offering tax incentives worth hundreds of millions. First this, California passes strict data privacy law. Then this, tech companies calculate impossible compliance costs. Then this, relocation studies begin. Then this, venture capital shifts investment. Then this, talent starts leaving. Then this, real estate markets weaken. Then this, more companies announce departures. That's cascading failure. When tech companies leave, suppliers and service providers fail. When those businesses fail, commercial vacancies increase. When vacancies increase, property values drop. When property values drop, tax revenues collapse. Economic analysts estimate that if even 30 to 40% of California's tech sector relocates over the next 5 years, the state could lose $60 to $100 billion in annual economic activity. That's permanent annual loss, compounding. And here's the multiplier effect. Every high-paying tech job supports approximately 4 to 5 additional jobs in the surrounding economy. When a software engineer earning $250,000 leaves California, that's the restaurant workers who served lunch, the retail employees, the contractors, the teachers whose schools were funded by that income's taxes. Industry economists estimate that 250,000 direct tech job losses could translate to 1 to 1.5 million total job losses across all sectors when accounting for multiplier effects. And California's state budget is heavily dependent on tech sector taxes. The top 1% of earners, heavily concentrated in tech, pay approximately 40 to 45% of California's personal income tax revenue. When those earners leave, the state faces budget deficits that make current shortfalls look manageable. Fiscal analysts warn California could face annual budget deficits of $40 to $70 billion if the tech exodus continues, forcing cuts to education, healthcare, infrastructure that would fundamentally change what California can provide residents. And the governor sits at the center of this crisis, under pressure from privacy advocates demanding he defend the law, from business leaders demanding modifications, from legislators whose districts depend on tech employment, and from voters watching their property values decline. And then it gets worse because the law creates enforcement nightmares. The California Privacy Protection Agency faces the task of regulating an industry worth over $1 trillion. Early enforcement actions show wildly inconsistent interpretations. What one examiner approves, another cites as violation. Companies have no clear path to compliance because regulators themselves can't agree on what the law requires. This regulatory uncertainty is actually worse than strict requirements. Companies can adapt to clear rules. They can't operate where compliance is subjective and penalties are catastrophic. So what you get isn't privacy protection. You get chaos. Here's the twist. A law designed to protect consumer privacy may actually harm privacy by driving tech companies to relocate to states with weaker protections where they'll continue serving California users, but without California oversight. Let that sink in. The irony is impossible to ignore. California can't enforce its privacy law on companies headquartered in Texas serving California users over the internet. So companies relocate, continue serving California consumers, but now operate under Texas law, not California law. The result, California users get less privacy protection, not more, because companies operate under weaker regulations in their new home states. The goal was stronger privacy. The result is weaker protection plus economic devastation, and it's not just regulatory failure, it's economic injustice. The law was sold as protecting ordinary Californians, but the actual impact falls hardest on working families whose jobs depend on the tech sector functioning. The software engineer who loses their job when their company relocates. the administrative assistant whose position is eliminated, the service worker whose restaurant closes when tech workers stop coming for lunch. They didn't exploit anyone's data. They just worked in an industry California's regulations destroyed. And look, privacy matters, data protection matters. But this is the question nobody wants to answer. Why didn't California study how other jurisdictions implemented privacy laws before creating requirements that tech companies say are operationally impossible? The EU's GDPR includes technical feasibility considerations that California's law reportedly lacks. Companies complain about GDPR, but they've achieved compliance. California's law goes far beyond GDPR in ways that cross the line from strict to impossible. Because here's the reality. If trillion-dollar companies with unlimited resources are saying compliance is impossible and choosing relocation, maybe the law's requirements aren't actually achievable with current technology. And then state officials talk about technical assistance, compliance guidance, enforcement forbearance. Think about that. The same legislators who promised privacy protection without economic cost now scramble to modify a law that's triggering the largest corporate exodus in state history. Not careful policymaking, reactive crisis management of predictable consequences. Major corporations aren't adapting by building separate California compliance systems. They're adapting by leaving. That's not defiance, that's basic economics. When compliance costs exceed the value of serving a market, you exit that market. So the contradiction is brutal. A law meant to protect Californians is driving away the companies employing Californians, eliminating the tax revenue funding California's programs, and potentially leaving users with less privacy protection than before. By March 2025, the pressure on California's governor doesn't come from one source. It comes from accumulation, from cascading consequences. Economic forecasters warn that if current trends continue, California could lose its position as the nation's technology leader within a decade. Industry analysts project California's share of national tech employment could drop from approximately 30% today to 15 to 18% by 2030 if the exodus continues, and the budget implications are staggering. California faces an estimated $40 to $70 billion annual deficit if tech sector tax revenue declines as projected. Here's what the numbers look like. An estimated 250,000 to 350,000 direct tech jobs at risk. Approximately 1 to 1.5 million total jobs affected when including multiplier effects. Between $60 and $100 billion in annual economic activity potentially lost. State budget deficits of $40 to $70 billion annually if tech exodus continues, and real estate analysts estimate property value declines of 20 to 40% in tech-dependent communities, not political talking points, economic projections based on current trends. So here's the accountability question. Will anyone take responsibility? When Meta, Google, Apple announce headquarters relocations, can the governor still claim the privacy law has no economic cost? When 250,000 jobs leave, can legislators say they protected consumers? Everyone who championed this law has a role in the disaster it's creating, and everyone has an incentive to blame someone else. This isn't partisan. It's about basic policy competence, basic understanding of technical feasibility, and basic recognition that good intentions don't guarantee good outcomes. If you found this investigation valuable, subscribe to Elizabeth Morgan right now. Drop a comment below. Tell me what you think. Are California's privacy protections worth losing the tech industry? Should laws require technical compliance that engineers say is impossible? What happens to California when Silicon Valley relocates to Austin? Share this video with your family, friends, co-workers. People need to understand what's happening to California's economy and why the state keeps losing the industries that made it prosperous. And listen, this story isn't over. Because if California can drive out its tech sector through regulatory overreach, what industry is safe? What happens when states compete through regulation, and the result is a race to see who can destroy their economy fastest? The full consequences are still unfolding. More companies are evaluating relocation, more economic impacts are cascading, more jobs are at risk, and whether California officials will acknowledge what their privacy law has done before the entire tech sector relocates and the damage becomes permanent.